You're listening to Audiology. Support this channel by becoming a member and be sure to submit your request for topics in the comments below. The Logan Act is a law in the United States that makes it illegal for someone who isn't authorized to do so to negotiate disputes with foreign governments on behalf of the U.S. It was put in place to ensure that no one could weaken the government's official stance by conducting their own negotiations. This law came about after George Logan went ahead and had unauthorized discussions with France back in 1798. President John Adams officially made it a law on January 30, 1799. Although the law's been around for a while, the only notable change came in 1994 when they updated the penalties. Before, violators could be fined $5,000, but now the fines fit under a broader category without a specified amount. Breaking this law is considered a serious offense, potentially leading to a 3-year prison sentence. Interestingly, throughout its history, only 2 individuals have been formally accused of breaking the Logan Act, one in 1802 and another in 1852. However, neither of them ended up being convicted. Back in 1798, when the United States and France weren't seeing eye to eye, President Adams decided it was time to try and smooth things over. So he sent 3 officials to France in hopes of negotiating peace. However, things didn't go as planned, and the talks fell through. Around the same time, a man from Pennsylvania named Dr. George Logan, who was a lawmaker and a staunch peace advocate, decided to take matters into his own hands. As a private citizen, he went over to France to try and ease the tensions during what is known as the Quasi-War. Now, Dr. Logan wasn't just anyone. He was a Philadelphia Quaker and a member of the Democratic-Republican Party, and his trip to France caused quite a stir back home. This was because at the time, the Federalist Party, which had control over Congress and the presidency, viewed Logan's freelance diplomacy as a direct challenge to their authority. Kevin Kearney, in an analysis for the Emory Law Journal, points out that when Logan got to Paris, he had several meetings with top French officials, including a powerful figure named Talleyrand. Logan made it clear he was there on his own terms, aiming to find ways to better Franco-American relations. He highlighted the anti-French sentiments brewing in the United States and described how some Americans were wrongly painting the French as warmongers. Interestingly, within days of Logan's discussions, the French government lifted a trade embargo and released American sailors who had been imprisoned. Although it seems Logan's visit was timely rather than influential, his actions didn't sit well with the Federalist majority Congress back in the United States, especially as Democratic-Republican newspapers praised him for his efforts. Timothy Pickering, then Secretary of State, was particularly irked and prompted Congress to take action against private citizens meddling in international affairs. This led to Representative Roger Griswold introducing what came to be known as the Logan Act, swiftly passed by Congress to prevent individuals from undermining official U.S. diplomacy. Despite this law aiming to dissuade such actions, it didn't apply to Logan for his actions in France due to constitutional protections against retroactive punishment. Logan's political career didn't end there, though. He went on to serve as a Democratic Republican in the U.S. Senate and even attempted another unofficial peace mission to England before the War of 1812, though without success. The Logan Act has remained mostly a paper tiger throughout history, rarely enforced due to concerns about infringing on free speech protections. Especially in the 20th century, as the Supreme Court became more concerned with individual rights under the First and Fifth Amendments, and as private citizens playing roles in foreign policy became a more visible issue, the Act has been debated but seldom acted upon. Title 18, Section 9. 53 of the United States Code makes it clear that any American, no matter where they are, is not allowed to communicate with a foreign government or its representatives without the United States' permission if they are trying to influence that government's actions in any dispute or disagreement with the U.S., or to interfere with what the U.S. is attempting to do. If someone does this, they could be fined or face up to 3 years in prison, or possibly both. However, this rule does not stop an American from reaching out to a foreign government or its agents to seek a solution for a personal injustice they believe was done to them by that government or its people. This was established back on January 30, 1799, as part of the original statutes and is now found in the Legal Code, specifically under 18 U.S.C. Section 953 as of 2004. The treaty clause in the United States Constitution, that's Article 2, Section 2, Clause 2, gives the President the responsibility and power to initiate and mainly handle negotiating agreements with other countries. However, these agreements only become official or treaties after they receive the backing of a supermajority. That's 2/3 of the Senate members who are there to vote on it. To boil it down, the President can propose and negotiate treaties, but it takes a big thumbs up from at least 2/3 of the Senate to make anything official. Writing for the Supreme Court back in 1936 in the case of United States versus Curtiss-Wright Export Corporation, Justice Sutherland shed some light on this process, essentially saying, when it comes to dealing with other countries, the President is the main voice and representative for the entire country. He's the one who gets down to the nitty-gritty of negotiating treaties, with the Senate providing their advice and consent. But it's clear that the Senate and Congress don't get to muscle in on the negotiation part. It's the President's show. This highlights a point made way back in 1800 by Marshall in the House of Representatives, emphasizing that the President is the only one who handles the nation's external relationships and is its sole representative in dealings with foreign nations. The goal of the Act is to prevent American citizens who do not have official authorization from getting involved in disputes or conflicts between the United States and other countries. Despite efforts to eliminate the Act, it remains in effect and can be utilized to penalize anyone who interferes in the United States' international relations without the appropriate authority. The United States government has warned that it could employ this Act to stop Americans from conducting transactions with other nations. A notable instance occurred in February 1941, when the Undersecretary of State, Sumner Welles, informed reporters that former President Herbert Hoover could face legal consequences because of his attempts to organize food relief negotiations with European nations. Throughout its history, the Logan Act has led to only 2 indictments, and both cases unfolded in the 19th century. Let's look into these unique examples. First off, back in 1803, there was a Kentucky farmer named Francis Flournoy who got into hot water for writing an article. He used the nickname "a Western American" when he published his thoughts in the Frankfurt Guardian of Freedom. What stirred the pot was his idea for setting up a new and independent state within North America that would be buddies with France, not part of the U.S. This idea didn't sit well with the United States Attorney for Kentucky, who happened to be picked by Adams and was even related to Chief Justice John Marshall by marriage. Although they went to the trouble of indicting Flournoy, nothing came of it. They never took him to court. Plus, later that same year, the U.S. bought the Louisiana Territory, which pretty much made Flournoy's separatist argument a moot point. Consequently, everyone moved on and the case was dropped. The second, and surprisingly the last instance when someone was indicted under the Logan Act occurred in 1852 with Jonas Phillips Levy. Levy wasn't your everyday citizen. He was an American merchant and sailor living in Mexico. He got a grant to build a railway across the Isthmus of Tehuantepec in Mexico, which is the shortest route across the country. Meanwhile, the U.S. Secretary of State at the time, Daniel Webster, was trying to persuade Mexico to sign off on a treaty favoring another set of American businessmen for the railway project. Levy didn't agree with that plan and wrote a letter to Mexican President Mariano Arista, encouraging him to reject Webster's treaty proposal. This action led Webster to push for an indictment against Levy under the Logan Act for interfering. However, the case hit a dead end when Arista wouldn't give up the letter Levy wrote, which meant the prosecutors had no evidence to go forward with the case, resulting in its dismissal. So these 2 stories underscore how rare and historically intriguing Logan Act indictments are, with each case offering a glimpse into the legal and geopolitical complexities of their times. Back in 1975, Senators John Sparkman and George McGovern made a trip to Cuba, where they met with local officials. This brings us to an important point about the Logan Act, which is designed to stop unauthorized individuals from meddling in disputes between the United States and other countries. However, the United States Department of State has clarified that this act doesn't stop members of Congress from having discussions with foreign officials if it's part of their job responsibilities under the Constitution. In the specific instance of Senators McGovern and Sparkman's visit to Cuba, the executive branch, while not encouraging the visit, was fully in the loop about its purpose and had even validated their passports for the trip. Senator McGovern was upfront during his discussions in Cuba, stating clearly, "I made it clear that I had no authority to negotiate on behalf of the United States, that I had come to listen and learn," as noted in his report titled Cuban Realities, May 1975. Senator Sparkman interacted with Cuban officials under similar conditions. The issues they brought up, such as the Southern Airways case and Luis Tiant's wish for his parents to visit the United States, were seen as fitting into the Logan Act's allowances. The Department of State therefore found that the actions of Senators Sparkman and McGovern did not go against the Logan Act's rules. Back in June 2007, Congressman Steve King attempted to prevent Speaker Nancy Pelosi from utilizing government funds for trips to countries that the United States considers sponsors of terrorism. However, his proposal was unsuccessful. Fast forward to March 2015, when 47 Republican senators decided to compose an open letter to Iran. This letter served as a notification about President Barack Obama's ongoing efforts to finalize a nuclear agreement with Iran and 5 other world powers. The senators emphasized that any agreement made by Obama could be undone by the following president if it wasn't ratified by the Senate. This action significantly stirred public opinion, leading to a petition on the White House's website. More than 320,000 people demanded these senators be prosecuted for exceeding their authority under the Logan Act. In a similar context, in April 2018, John Kerry, the former Secretary of State, met with Iranian officials to attempt to sustain the nuclear agreement. A spokesperson for Kerry stated he was encouraging Iran to adhere to the deal. Stephen Vladeck, a law professor, defended Kerry's actions, asserting they were consistent with current U.S. policies rather than undermining them. Vladeck pointed out the problematic aspects of the Logan Act, suggesting it was unlikely anyone would be prosecuted under it. An intriguing development occurred when Jeffrey Berman, a former U.S. attorney, disclosed that he was pressured by the Justice Department to indict Kerry under the Logan Act for these meetings. Nevertheless, Berman's office, as well as the U.S. Attorney's Office for the District of Maryland, opted not to pursue charges, standing strong against the pressure. Jumping to August 2024, former President Donald Trump reportedly attempted to influence Israeli Prime Minister Benjamin Netanyahu over ceasefire negotiations, fearing it might benefit Vice President Kamala Harris in the forthcoming election. This allegation was reported by Judy Woodruff on PBS during the Democratic National Convention, but was later corrected by her. Woodruff admitted her error, explaining her comments were based on earlier reports from Axios and Reuters, which she had not verified for updates. These reports suggested Trump was encouraging Netanyahu to agree to the deal, contrary to her initial statement. Axios later clarified that Netanyahu's office denied any conversation with Trump about the Gaza ceasefire, correcting the record. Thanks for watching. Share your thoughts in the comments and subscribe for more content.